There was no precedent for martial law in the U.S. until 1814, when then General Andrew Jackson placed New Orleans under martial law as part of his preparation of the defense to fight the Battle of New Orleans in the War of 1812. This was considered an affront to the Constitution at the time, and after the war ended, suit was brought against Jackson in 1815. In this suit, the Supreme Court of Louisiana found that Jackson had no authority to declare martial law. Furthermore, after relinquishing the city back to its civilian authorities, Jackson was found in contempt of court and fined $1,000 by the local federal district judge. In 1842, then President Andrew Jackson petitioned Congress to refund the fine plus interest. In 1844, Congress enacted the Refund Bill, and by doing so gave at least tacit congressional approval to his actions. In addition to all of the drama surrounding Jackson's actions, in 1842 the Dorr War broke out in Rhode Island, which caused the Rhode Island General Assembly to declare martial law. These actions were challenged in the 1849 case Luther v. Borden, in which the U.S. Supreme Court upheld the legitimacy of the Rhode Island General Assembly's declaration of martial law. This Supreme Court precedent seems to be the point at which the authority for martial law in the U.S. was fabricated into being. However, to this day, there's still no in-law argument for the legitimacy of martial law, nor has the Supreme Court held in any other ruling that martial law is a legitimate authority. But all subsequent invocations of martial law have leaned on this precedent for their legitimacy.